We have two triads so far, just to make sure I haven't missed anyone. First we'll have John McGinnis, Rick, and Stephen, and then I had Will, John Harrison, Don Drips. Any additional? I have Larry and Mike. Keep on. I'll try to catch their additional. But first, pass it to Bernadette. Yeah.
So thank you, Cy. I think we agree about a large swath of this material. And the thing that I would want to point out in the first place about what you say about the general pardon, I would agree that there really is only a formal distinction between granting a general pardon and then having each individual within that sort of pardoned in seriatim. But I guess I want to point out this possible difference between what I'm calling, or what is being called an oblivion, and a general pardon. And partly because I think that this history of oblivions and also amnesty demonstrates something about a different conception that actually does involve some of the consequences of pardon that we agree are not solely the president's to create. And so I'm not suggesting that the president couldn't necessarily grant a general pardon, but more that once the court sort of says, well, pardon and amnesty are the same thing, that's maybe incorrect, and that there are certain ways in which in order to achieve the effects of an oblivion or amnesty, the president would have to collaborate with Congress and have a sort of joint effort in that regard. I think that's where I'll stop for now.
All right, so we'll start with the first triad, which will be John McGinnis, Rick, and Stephen. John?
Yes, well, I very much enjoyed this paper, Bernadette. I guess my question is both specific and maybe methodological about your common law theory, which is, I guess my question is, why don't, the paper doesn't really begin with trying to focus on the text. It really jumps in the common law, and the text comes in really at the very end, which seems strange to an originalist. And in specific, some of the things that here, it seems quite clear, as you say, the president has a pardon power. Some of these other, when you talk about the incidents about Congress, well, we could explain that as textually. We look at the pardon power. It doesn't have power over certain effects. Moreover, Congress has power over naturalization. Congress is about the appropriation of monies out of the Treasury. We might understand that as Congress or other matters that Congress could have necessary and proper powers to bring in the effects of the pardon to even more generally than that. And maybe then we'd look at the common law to understand that, but there seems to be a structure in the Constitution for that. And then to Cy, what worries me a little in looking at beginning with the text is to say, well, does Congress have a power of general amnesty? It's enumerated powers. It's not there. It may well have some power to grant immunity going forward because that's a part of its commerce power. But don't we need to trace this power in some ways to a textual provision? And aren't these axioms in some sense of originalism?
Rick?
Yeah, I like the paper very much. I'm in kind of my secret life. I do a 17th century English stuff. So I'm sorry? Yeah, well, someday it's going to be a really good one. So I enjoyed being educated about this stuff. I take the project to be to investigate the history for the purpose of kind of allocating various pardoning powers, some to the legislature, some to the executive, and you do it by saying, well, kind of what was practice, pre-constitutional practice. What I get from reading the paper, and I also get from some things that Cy said, is that you look at it's kind of a mess. That is to say that there's a range of activities which are some undertaken by the king, some undertaken by parliament, some undertaken cooperatively. So you have on one end you have the individualized pardon, on the other hand you have the act of oblivion, but then you have a general pardon, you have an act of general pardon, you have an act of grace, which I I'd be like, know what that is. I'm not sure. I've come across that. You have the act of oblivion, but it's not just an act of oblivion. You have an act of oblivion with exceptions, an act of oblivion with exceptions for life or exceptions for property, so that there's this just kind of things begin to disintegrate, and certainly over the longer range of time. And the question is, what kind of lessons can we infer from that experience?
Okay, well, why don't we first try it with Stephen?
Thanks. I really enjoyed the paper. John McGinnis actually said some of what I was going to say, but I want to put it, I guess, slightly differently, which is, thinking doctrinally, right? Isn't the real problem in the Supreme Court cases in the 1870s Congress and the president disagreeing, right? And not necessarily fighting over who in the abstract has the power, but fighting over whether Congress or the president wins, as in Klein, when the president says one thing and Congress says something else, and the Supreme Court takes sides, and then Congress steps in again. So it seems to me, John mentioned immunity. I mean, I think of the FISA Amendments Act of 2008 and telecom immunity, right? Congress has plenty of power, presumably from somewhere. I mean, even I suspect Congress had power to enact the FISA Amendments Act of 2008, right? To accomplish functionally the kinds of things that, at least to a large degree, it seems like Parliament could have done at common law. The question to me, I think, arises in the unique American context because of the potential for conflict between the legislature and the executive that my own sort of amateurish senses wasn't quite as present in pre-revolutionary England.
Great. Thank you so much. So I'll start actually from the last question. I think that you're right, Steve, that Congress does have plenty of power to do things that look a lot like amnesty. And one case that I don't really talk about here, but sort of establishes that and also doesn't really establish where that power comes from is the Brown against Walker case, and where they say, well, Congress can clearly immunize people from criminal liability for things that they testify to, and then that's fine as a way of getting around the Fifth Amendment right against self-incrimination. And they say, well, in England, Parliament had the power to grant amnesty, and so there's no reason to think that Congress was deprived of that power. They don't really say it actually corresponds with any enumerated power that is given in Article 1. So I find that a somewhat unsatisfying explanation of where the power comes from, but it's definitely there is this notion of concurrent power that does come up through the cases at various points. And you're right, I think that the problem is when Congress and the president disagree. I mean, I think part of the problem with the post-Civil War cases is basically that they switch from, in an earlier moment, saying, well, the president clearly has this great pardon power that also involves amnesty and all of these other entailments of amnesty. So clearly, we can assume that he'll be able to do what he's planned to do in Klein. But the dissenters in Klein say, well, there's no reason to think that the president can actually dispense money from the Treasury, right? And that's exactly the point that then comes up later in Knott, where they go the other way. And so I think that the problem is sort of thinking of pardon and amnesty as involving the same kinds of things and not realizing the ways in which Congress actually has to collaborate with the president in certain respects to fully effectuate something like an amnesty. And then in terms of Rick's question, I mean, I think that's exactly what I'm trying to sort of demonstrate, that there are a range of alternatives that are available at the time of the founding, and certainly it's not irrational at all to believe that the president would have the power to grant amnesty, at least to a certain extent, as well as pardon based on the sources. That it seems like there are conflicting traditions. Certainly the different colonies have different visions of the extent of the pardon power. And interestingly, if you look at the Whiskey Rebellion, there are offers both by President Washington and by the governor of Pennsylvania of some kind of amnesty. And the governor of Pennsylvania seems to be sort of suggesting that there'll be an act of oblivion, but without really consulting the legislature all that much. So there's a change in meaning even of what an act of oblivion would be and how legislative it might be. So I think that my point is basically to say, well, we have this range of meanings, and that looking at the original context can give us this sense of a diversity of meanings and a range of meanings that then should furnish the grounds for our debate about the allocation of the powers in the present. And so that that this doesn't definitively resolve what the, and I think I don't have to come down, and maybe others will disagree, on the side of whether I want to be in the Stanley Fish intentionalist camp or the textualist camp, but to say that, you know, if you're looking at the intentions, you can't exactly tell in terms of the intentions what the intention was, and then also if you're looking at the text, it's not, pardon doesn't necessarily include amnesty, but it might, and that in either way, we sort of are left with these alternatives that we then have to make a decision about, you know, given the full context, and that decision is not dictated by the historical context. And then that leads me to John McGinnis's question. And yeah, so I think that's a great question about where the text comes in. I guess the text comes in for me with the notion that pardoning might be a term of art, right? So that it might be like habeas corpus, and that it has a particular kind of legal meaning, and that it might not be a legal meaning. It's partly a legal meaning within a judicial arena, but it's also partly a legal meaning within a separation of powers context and within legislative and executive branch activities. And so that in order to flesh out what that meaning might be, we then have to look back at the common law context, both in the English and colonial settings.
If I could just say something in response to what John said. Certainly, originalists are going to be looking to text, and if you wanted to think about what the text meant, I think it also makes sense to look at the antecedent state and the Articles of Confederation, right? So in that era where Congress has very limited power, Congress is both issuing pardons and giving the commander-in-chief authority to grant pardons. And so I think there's some sense that the legislative powers that Congress had to create the crimes also gave them the power to forgive them. And you talked about the commerce power as maybe allowing them to create an exemption going forward, but maybe not a pardon. But you have situations where people create statutes and then after the fact change them, not only going forward, but changing them in a sense going back, right? So you have folks who are in the Army who are getting a pay from the Congress, but later on they decide to give them some benefit that they didn't bargain for. And you might say, well, where's the enumerated power to give them this extra benefit? And I guess the idea is, well, we're going to get better soldiers in the future if they know that we can not only give them a contract that gives them certain benefits, but also give them extra benefits afterwards as a show of our esteem for the work they've done for our country. Apart from that sort of understanding of congressional power, if you've got someone in jail, right, it seems to me you could say, we're deciding what we're going to appropriate money for, and we just decided not to appropriate money for this person staying in jail. Right? So I think there are ways of getting to a congressional power to do this. On the distinction between amnesty and pardon, I don't see a distinction in the literature between those two phrases. Washington tells Congress he offered amnesty to the rebels in Pennsylvania. What I see is a distinction between what Congress can do and what the president can do, and the president just can't go back and take money that's already been, that's already clearly in the Treasury and give it back. But that's not so much a distinction between amnesty and pardon. It's just the fact that Congress and Parliament controlled the fisc and the executive didn't.
Okay. The next group we have Will, John Harrison, and Don. Start with Will.
So my question is about the different possible consequences of legislative and executive pardons, and I guess it leads me possibly to be skeptical about legislative pardons. So, and in particular, the consequence I'm wondering about is the effect on the judgment of conviction. So obviously, most people who get a pardon, what they care about is getting out of jail or getting their property back, and sort of the more tangible consequences. But another important thing that happens when you're convicted is that there is a judicial judgment of conviction. And that judgment can have consequences in the future because it can have a preclusive effect, and judgments have all sorts of legal effects that matter. So my question is really, does a presidential pardon affect the judgment? Does a legislative pardon affect the judgment? And what should that tell us about whether there are presidential and legislative pardons? And it seems to me it's pretty plausible that the presidential pardon does affect the judgment, because even though the judiciary has a power to issue judgments, it's usually final. There's this special enumerated power about pardons, so it's plausible to say that that allows the president to get rid of the judicial judgment of conviction. But then what about legislative pardons? The general rule is that the legislature doesn't have the power to eliminate judicial judgments, to revise them by legislation. That's true even though in the colonies legislatures did do that, did get rid of judicial judgments. The Supreme Court has said that rule didn't carry over to the Constitutional Convention, and they have a bunch of history that seems pretty persuasive of why that's true. So then you would think, well, maybe the legislative pardon can't get rid of the judgment. That suggests already the legislative pardon is substantially more limited than the presidential pardon. And then maybe that means that the legislative pardons are actually questionable altogether, not because they exceed Congress's enumerated powers, but because they violate Article 3. At least as people who've already been convicted. Maybe prospective people who haven't yet been convicted might be different, but people who've been convicted might be different.
Yeah, John Harrison.
These are some more structural questions about whether Congress can have pardon power and amnesty power and oblivion power. First point, the Federal Convention took the royal prerogative and gave most of it, or they gave any of it to Congress. So Congress has prerogative powers like the weights and measure power. The one bit of the prerogative that the president got was the pardon power, and it's not like the treaty power where he needs to get the Senate to go along with him. He's just got the pardon power. So that's one indication. Maybe they took that one and gave it to him. Second thought, that an oblivion is such a powerful thing, reshaping social relations, telling people what they can and can't talk about, that if you think that the necessary and proper power picks up only incidental powers, and that if something's really huge, the fact that it's not on the list tells you that it's not on the list. That's another reason to think it's not on the list. And finally, and I think this is connected to what Will was just saying, the central examples of congressional power, because Congress has all legislative power herein granted, operate prospectively. One of the reasons Congress sometimes can't readily overturn judicial decisions is they can operate only prospectively. When they can operate prospectively, they can do it. They can do Wheeling Bridge under certain circumstances. But an oblivion or an amnesty looks in part retrospective, so there's a structural difficulty with it.
And Don.
Yeah, I just want to pick up on what Cy was talking about, is the difference between the retail workaday pardons in the criminal justice system and the sweeping political pardons after emergencies. And in the common law criminal justice system, the pardon power was an absolutely integral part of the system because capital punishment was the output. And so you needed all these discretionary benefit of clergy, pardon, strict scrutiny of indictments, and so forth, all as a way of moderating capital punishment. And you couldn't rely on prosecutorial discretion because crime was privately prosecuted. And while the Crown could nollie that was a very complicated. You had to find out about it before the conviction was rendered, because once judgment was entered, you couldn't nollie a judgment. You had to rely on the pardon power for that. So that whole process became an anachronism almost as soon as the ink was dry on the instrument, because capital punishment is greatly curtailed even in the first Federal Criminal Code of 1790. You start to see the monopolization of prosecutorial power in public hands during the course of the 19th century. And so just sort of by point of information, I guess, that was something that was thought to be absolutely indispensable in the old common law system of criminal justice, rapidly became dispensable, and nowadays you can do it through prosecutorial discretion, and you might not have any reason to do it at all because of the decline of capital punishment. So in Thomas Jefferson's proposed Penal Code for Virginia in 1779, it proposes to abolish, first curtail the death penalty dramatically in favor of corporal punishment because they didn't have a penitentiary. But then the sections, two subsequent sections, one eliminates the fiction of benefit of clergy as this antique process, and the next section says we also abolish the pardon power because we don't need it anymore. And so I'm not sure how it comes up against what John McGinnis was talking about. The text is pretty darn clear, right? But the text has been wrenched completely from its historical context.
And just in terms of the text being wrenched from the historical context.
Well, the text is still with us, but everything that was presupposed about it is gone.
Mm-hmm. Okay, yeah. All right, so I'll I'll start backwards again. I mean, so I think you're right about the general pardons. I mean, one thing you could say is that actually the pardon power hasn't been that much used recently, so that in a sense that's reflecting the difference in the historical context that you're talking about, or so that even if the text is clear that pragmatically presidents haven't been using pardoning to the same extent as previously, and so that in effect the historical situation, the fact that the historical situation has changed is being acknowledged somewhere, even if not textually. And certainly, yeah, the pardon power was a much more crucial routine component of criminal justice during the founding period or preceding that, and also conditional pardons were a very strong tool of the state. Both
people go to Australia.
Right, exactly. I mean, if you look at the statistics about how many people were transported versus being given the death penalty, it's extremely important. And of course, actually, there are pardons conditional on transportation to America too, and so that's another way in which the colonists are very aware of the power of the pardon and the significance of pardon power. I mean, I guess this gets back though to a distinction. You were saying the workaday pardon versus the exceptional pardon, and this gets back to I think where I might disagree with Cy. I think part of the problem from Washington onwards is this forgetting of what amnesty really meant, right, or what the entailments of amnesty really were, and the differences between even a general pardon and an amnesty or oblivion. And that, in effect, I think this also goes a bit to Will's point, that part of the importance of the oblivion was actually that it was before prosecution, right, so that it was about not being able to raise certain kinds of issues within a court of law or elsewhere, and having to actually, have a forced suppression of these particular kinds of moments of crisis, and that it really did come out of particular moments of crisis. And I think that this also perhaps responds a bit to part of John's point, which was that oblivion seems pretty powerful, and one of the ways in which it's so powerful is that there was a prohibition against actually mentioning the events that had led up to some kind of crime or some kind of prosecution, potentially. And actually, interestingly, in the colonies, there are some greater specifications of punishment in terms of punishing people who violated an oblivion than even in England, so that they would be subject to corporal punishment or put in the stocks if they mentioned the offending acts. Of course, that violates other provisions of our Constitution, i.e. the First Amendment. So we might say, well, there are certain parts of oblivion that are incompatible with our constitutional system. But I would want to sort of retain this distinction between oblivion and amnesty on the one hand and the regular pardon, partly because of the conditions under which they're exercised and also because of their entailments. But so then returning to John's point, I think that the points that you raise are quite powerful, and I think they do weigh against thinking about Congress as capable of issuing acts of oblivion in a more general sense. I mean, I think that they counterbalance some of the arguments I'm making. I'm not sure that they're determinative, but I do think that the fact that that oblivion isn't on the list of enumerated powers is specifically a good point, and the fact that the president does get the pardon power, and that there isn't a sort of explicitly textually based congressional power to do that, I think is a good counterpoint. And then in terms of the getting back to Will's point, I guess I would just emphasize that I think about oblivion and amnesty as having more of a prospective valence, although also having to do with, so post-conviction, say post-prosecution, kind of restoring people their rights. I think there are obviously, like in terms of returning property, that would be something that Congress could do to people whose property had been confiscated, and in particular in these circumstances of rebellion or other kind of civil unrest.
Can I just say something real quick? I've always been confused about this notion that, I said that the pardon blots out the guilt, but I don't really know what that means, because obviously anybody's allowed to say, or allowed to think at least, the person was guilty. Bernadette's given us a greater sense of what that might mean. Parliament might actually pass a statute that makes it a crime to discuss some prior act. As far as this prospective retrospective thing, I'm a little confused by that as well. So John says Congress only has the power to act prospectively and very little power to act retrospectively. But when Congress passes a pardon statute, assuming that it can do so, it's just saying in the future you are not to take into account the fact that this person may have committed something, right? So in that sense, it is prospective. They can't go back in time and prohibit people from doing whatever it is that they did. If they can do that, then it's ex post facto, some sort of criminal sanction. And as for Will's question about the judgment, if you think that Congress has the power to pardon, and if you think part of the pardon power was to wipe away the judgment, then it follows that Congress can wipe away the judgment. Congress exercised a pardon power during the Articles of Confederation, and it granted authority to the Commander-in-Chief to grant pardons and reprieves. You have to think that either that they were wrong on the first point, or that even though they were wrong on the first point, they could delegate power that they couldn't exercise themselves when they gave the President the power to pardon court-martials, etc.
Which Congress was that? Sorry.
The Continental Congress.
If I could jump in on just on Will's point, and I'm glad Cy mentioned it, because Will questioned whether Congress would have the power to override a specific judgment, even perhaps if Congress has a general legislative power. I mean, INS v. Chadha, you have Justice Powell saying that even though Congress obviously has the immigration naturalization power, at least he thinks Congress doesn't have the power to override a specific individual judgment. So one could make an argument that even though, say, Congress has a pardon, there is some traction to that argument. So I don't, Will is the master of judgments, and he wrote a wonderful piece about it. I wonder what that means, though, right? So if Congress just says whatever consequences from the judgment aren't going to apply in the future, maybe the judgment is still in Westlaw or it's searchable, but what difference does it make? I don't really know what it is what power does the judgment have independent of its consequences, and if there are no consequences, fine. Congress will be happy to say that the judgment is still on the books, but it has no legal effect in the future. We're doing pretty good on time, so Will wanted to jump in.
As in the Congress example, I guess the point is you could think that in the Continental Congress, they didn't have the same rules of judgment finality as the constitutional structure ultimately adopted. So it's not that they were delegating a power they didn't have. It's just that once we had a stronger judiciary with stronger judicial finality under the constitutional structure, this particular form of judgment override wasn't possible anymore. As to the exact consequences of the judgment, despite writing something about this, I'm not entirely sure how much Congress can and can't do. I'm pretty sure Congress can't override the rules, the basic rules of preclusion from a judgment. Leaving in Westlaw, they can't say, but in the future, like all judicial cases should treat this judgment as if it didn't exist. And that I think would be a big deal.
All right, so we'll move on to the next triad, which is Larry Solon. Starts off.
I like the paper very much, Bernie. I'd just like to push you a little bit on what your actual theory of the meaning of the clause is. So in your oral remarks, but not in the paper, you talk about the possibility that you're inclined to view the pardon power or the term pardon as a term of art. So I'd like to suggest that there are three possibilities here. One possibility is that it's not a term of art, that the public perfectly well understood what a pardon was, and that there was a sense of pardon distinct from the pardon me sense, right, that was referred to in that the Constitution was using. And so the question there is why not the public meaning or conventional semantic meaning that was clearly understood at the time. If it's a term of art, then there's a second and a third possibility. So the second possibility is that it's a thin term of art, right? Not all terms of art are thick. It doesn't have to incorporate all of the pre-constitutional practice. And the way to test that would be to ask the question whether or not the relevant members of the linguistic sub-community that were employing the term of art would have recognized that there could be a variety of legal practices that would be pardons, right? So that there could be a variety of things that we would refer to as a pardon. A pardon might, that had the effect of what you call an amnesty, a pardon that didn't have that effect, and so on and so forth. The third possibility is that pardon is a thick term of art. That is, that some large part of the practice as it exists at the time the Constitution was drafted, of the specifics of the practice, would have been understood by members of the relevant linguistic subcommunity as built into the meaning of pardon. I took it, but I may have misunderstood you, that you meant that pardon was a term of art in this third sense. And my question for you then is, I don't see the evidence in the paper, right, that would be necessary to make out that claim, right? Presenting the historical evidence of what the practice is not sufficient to establish that the relevant linguistic subcommunity would have understood that practice as built into the linguistic meaning of the term or phrase. And just one final invitation then is to for you to say just a little bit more about how your general theory of common law constitutionalism impacts on this question, because it seems to me that there are obvious possible connections between your general theory and the choice between thin and thick terms of art.
Mike.
Okay, so I also like the paper very much, Bernie, and like your comments as well. So my head's kind of spinning here, sort of. Keep on trying to figure out, so before I read the paper, I'd actually got maybe written 5 pages about the pardon power and the issue of departmentalism, so pretty much a novice in the, that's all I've done about it, so pretty much a novice in the area. So before I picked up the paper, I would have assumed that, Congress did not have authority. And now I've been sort of going back and forth, because the big question I had initially was the enumerated power point, and that's what I was going to ask here, but obviously there's a lot of water under the bridge here on that. So I guess where I'm at now is thinking that, okay, so the president has the pardon power, and Congress does not have an enumerated power, obviously, with respect to acts of oblivion and the like. And so then the question is, how much does Congress get through its necessary and proper power? And I guess I find attractive the idea, as Cy suggests, they get some powers, but a sort of real limitation, maybe for the reasons that Will suggested about judgments, so there's then suggests a kind of prospective aspect to it, not this idea of forbidding the mentioning of the issue, and so I'm kind of feel comfortable with that position. I mean, obviously there's and the main argument I see against it is Cy's point that the Continental Congress is that a point against it, and if it is, I guess I'd like to hear more about that Congress's powers, because I would normally be quite sort of skeptical about assuming that, I'd like to know what power they were exercising and to what extent one could then impute it into to a Congress that had enumerated powers of a different sort.
And I think Vic.
Yeah, I too was going to talk a lot about where Congress gets the power, but I find myself in large agreement with Cy. It reminds me a little of the debate in the Ocentro case about where Congress gets the power to pass the RFRA. I mean, I think it's implicit as applied to federal agencies. I think it's implicit in whatever power Congress had to authorize those agencies to act. In this case, it would be prosecution and incarceration, and if you need the spending, you've got that. I mean, Will's point about there may be limits on Congress's power to eviscerate judgments, even if true, is not a broad-based argument against congressional power to issue pardons, but a limitation on that power in the same way that the Appropriations Clause may be a limit on the president's power to issue or effectuate certain pardons. Certainly, on this prospective, retrospective certainly there's some things if Congress tried to do in a backward-looking way, for example, to try to take away restitution that had been given to a victim by virtue of an earlier judgment, that might constitute a takings or the like. But beyond that, I'm not sure why backward-looking congressional power in this area is so dangerous. It's true that ordinarily we think of the legislature as acting in a kind of a broad-based, non-person-specific and prospective way, but it's also true that most of the time Congress is doing something that harms or regulates people, not giving them a break. So that's why I think Chadha really isn't, Powell's opinion, Chadha really isn't on point, because Powell was concerned about a legislative kind of punishment, not a legislative grace. So for what that's worth.
So starting out with Larry's point, I mean, I have not, I guess I would like to talk more with you about it because I am not sure whether I think it's a thin or a thick. I do want to say it's a term of art rather than simply an ordinary word within circulation, but that I'm not entirely sure whether I think it's a thin or thick term of art. And part of my part of it is that, you know, so when you were talking about the thin term of art, you said that would the relevant members of the subcommunity think that there are various things that pardoning might mean. I do think that they would have thought there might be various, especially allocations of the pardon power. So another part of what the Continental Congress does is that it suggests to states to pass acts of oblivion in relation to various conflicts that arise about borders and other things, and says, well, those states that, you know, we would like the legislatures of those of most states to pass acts of oblivion, but also in those states where the governor can do it, then the governor should do it instead. So there is this sense of a diversity of viewpoints, that there might have been a notion that, well, pardon means a variety of different things. We're going to kind of include it. It could mean a range of different options, rather than necessarily being what you're calling a thick term of art in terms of cutting out certain sort of relevant possible meanings. And in terms of how that is connected with the general project, I mean, my general project really is to look at the common law backdrop as providing terms of art that we have to understand through various practices by lawyers and others within the, you know, judicial and legislative arena, but that also, that to a varying extent, people are aware of jurisdictional differences in meaning or not. And so I think that might complicate my answer in general to this question of whether they're thick or thin terms of art, and I need to think more about that, I think. And in terms of Mike's point, I mean, I guess I would emphasize that I think it's not only through the necessary and proper power that Congress would get more capacity to issue something like an amnesty or oblivion, but even through something like the war power potentially, because if we think about, or the treaty power with the Senate, that if we think about amnesty as being, in a sense, a kind of transitional justice, that it might be part of those other powers that we think of as more congressional. Of course, you know, there have been more presidential uses of those recently, but that might be one additional hook. And then in terms of the limitation with respect to judgments, I'm comfortable saying that there might be, I haven't thought enough about that to really answer it fully, but that Will might be right, that there might be a limitation of the pardon power with respect to, or congressional pardons with respect to prior court judgments, but that would just be another limitation on Congress's power, just as, you know, the president is limited in terms of getting money from the Treasury to effectuate an amnesty. And I think that also goes to Vic's point. And one thing further I would say that say on Vic's point is just that we do accept generally that Congress can grant immunity in various ways, and so that part of the grant of immunity is, in a sense, looking backwards, but prospectively thinking about what a prior act is going to mean judicially or otherwise. And if we think that Congress can grant immunity, then that's part of a kind of amnesty.
If I could just say just one quick thing. It wasn't just the Continental Congress granting pardons. It was also state legislatures in states where the state constitution didn't expressly grant any pardon power. And I think this goes back to what Vic said, and since Vic agreed with me, I want to agree with him as well. It's sort of redundant, but I think the point is that if you've got power over a subject matter, the claim would be you also have power to forgive the violation of the subject matter. And so it wouldn't just be the Continental Congress, it would be these other examples as well, where the state legislatures were also thought to have pardon power, even though it didn't say anything. And I understand that it's a little bit different in a constitution where you grant power to the president. You could certainly read that as preclusive. So I'll stop there.
Okay. We have 10 minutes left, so just encouraging perhaps conciseness. The next triad is Michael Paulson, Hannah, and Larry Alexander. Michael.
Bernadette, I think this is really interesting, and a lot of what the real originalists and textualists are trying to do is help you find a textual, structural argument that supports this history. Okay? A lot of what I was going to say was said by Will or John, but I think I have it all figured out now. Okay. Building on Larry's point, the fact that the Constitution grants the president the power to grant pardons and reprieves does not seem in and of itself sufficient to import all this history and confer a legislative power. That just, the textual disconnect doesn't work, doesn't seem to bring it all in. That doesn't mean there isn't congressional power in some other source, but you have to look for it. I think Congress can't. Cy, you said something totally wrong. The power to create is a power to forgive. I'm not so sure that's right. I think a better way to put it might be the power to criminalize. Whatever gives Congress power to make something criminal is a power to uncriminalize, to rescind that criminalization. Okay? And that it might not fall within the usual ban on retrospective legislation because it is not an ex post facto law or a bill of attainder. But I think Will is right, and I'd put the point more strongly, that Congress can uncriminalize, but if somebody has been convicted and is in the midst of serving a sentence, for example, I don't think Congress can unconvict. I don't think it can abrogate the judicial judgment, the effect of the prosecution. That power appears to be conferred exclusively in the president. Congress could grant an immunity before prosecution. Congress could repeal the substantive law and make it retroactive to a date prior to when it occurred, but I don't think it can unconvict someone.
Okay, Hannah.
I think Mike Paulson is exactly right. But I wanted to make a slightly different point. We're talking about Congress doing this, but presumably Congress is going to act by passing a statute. And veto overrides are pretty rare. So when they pass a statute, it's going to have to be signed by the president. So if Congress wants to pardon someone or grant an amnesty and the president disagrees, then Congress is not going to be successful. Whereas if the president does agree, why isn't he just granting a pardon in the first place?
And Larry Alexander.
Well, as is true, so many things, this is, I now have some light in what was previously terra incognita for me, and I was always happy when I got the casebook I'm now using to see that U.S. versus Klein wasn't in there, because I always got confused in trying to explain what was going on in U.S. versus Klein, and now I know why I'm confused, even better. So my hand went up when John Harrison was making comments, and then I started to take myself off because of Cy's comments, which were pretty much echoed what I was at least going to ask about, not to assert, and Vic Amar's subsequent one. So I was thinking there are a lot of limitations on Congress's ability to undo things. There's the takings clause, the impairment of contracts clause. There are upsets of vested rights. There's ex post facto clause and bill of attainder clause that are limits. But beyond those, now, so Mike Paulson suggests, well, there's another one, which is you can't uncriminalize. You can't, even though you have the power. I assume, whatever power you had to write a criminal statute, which in the pursuance of whichever power you're doing it, whether it's the postal power or commerce clause, I would have thought that entails the ability to change the criminal law, perhaps to to forgive violations, and even let people out of jail. You're funding the jail. You're the one who, and now you want to change. I mean, so the thing that was always confusing about U.S. versus Klein was, why was this treated as some sort of affront to the judiciary as opposed to just changing the rule of decision in midstream? That was always kind of the difficulty. And now, it's possible the Constitution, beyond those particular limits, also limits Congress in changing things in midstream in various ways. But I'd have to see a reason why. I don't know, it would seem to me just ordinarily to be the case that as long as it's not a bill of attainder, an ex post facto law, or depriving somebody of property, it can prospectively tell people to forget about something that happened in the past. You can only act prospectively. You can't rewrite the past, but you can tell people how they should regard the past in the future.
And I'll hand it to you guys. And we have about 5 minutes left. There's a duo, not a triad, still waiting to question, but.
All right, so I'll try to be very quick. In terms of Mike Paulson's point, so I see what you're saying about that the history. You're thinking that I'm asking the history to bear too much weight and not the text. I guess I want to make clear that I'm sort of making two separate points, and that one of them is based on the notion of the pardon power in Article 2. And what I'm trying to say is that we have to look at the meaning of the pardon power and what pardon meant and didn't mean, and that pardon might not have included something like oblivion or amnesty. And so that, in one respect, it's a limitation on the extent of what pardoning meant under Article 2. And then I agree that then you have to come up with some other justification for finding something like pardon or amnesty for Congress, but that once you disaggregate pardon from amnesty and recognize that they might be two different things, that then you are sort of more able to see the ways in which Congress already has powers that lead into something like amnesty. And then in terms of Hannah, I think that's a great point about the president signing whatever bill it would be. I mean, I would say that the part of, and I agree with Cy about some of the reasons why the king wanted to have Parliament agree in pardons, but I think part of it also, there's a sort of democratic accountability point that once you actually are trying to have something like an amnesty when there has been a conflict within the country that's more a larger kind of political conflict, that you might want actually the greater buy-in of having Congress actually weigh in as well as the president, that it's not simply an executive decision. And then to Larry Alexander, I think that this issue of whether Congress can do something at least that doesn't violate ex post facto or the Bill of Attainder clauses, I would agree. I think that Congress could repeal a criminal statute and have that repeal sort of effectively not erase the conviction. So I think that you're right. It's not going to erase the conviction, but it would erase a lot of the entailments of the conviction. And so I don't think it could interfere with the case in the middle of when the case was ongoing. So that's the Klein case where it's trying to interfere with the appellate jurisdiction of the court and basically say a pardon means not what it says, but something else. And so it can't exactly do that, but I think it can erase a lot of the entailments of what a conviction might mean otherwise. So, I don't know if you have.
Well, I agree with Larry.
Okay. So we had, Myman and David had maybe finish us off. Did you?
I like it a lot. This may be a little tangential to the discussion so far, but there's a great book by called Albion's Fatal Tree by the English Marxist historian E.P. Thompson. And basically the thesis of the book, it's a great book, is that the pardon power was very extensively used by the king in 18th century England, where the death penalty was statutorily very pervasive, not just as a sort of routine part of the administration of justice, as Don alluded to it, but as a very personal technique for building gratitude and loyalty to the person of the sovereign. And there's a lot of history to that Roman emperors did that. They would even call themselves Clement, that the popes called themselves Clement. And the implication is that there's sort of a, in one sense, a good aspect to this, that gratitude is good, loyalty is good, servility is bad, and that there is a building servility element to this. So, is there anything in the constitutional history of this that kind of seems to explicitly or semi-explicitly take on that kind of Weberian idea that on the one hand you've got charismatic personal government and the pardon is part and parcel of that. On the other hand, you have the rule of law, the institutional pole, routinization, and that might have implications for whether you read the pardon power more narrowly or more broadly in terms of congressional power.
David, was yours crucial to jump in?
No.
Okay, why don't we wind up very briefly, 1 or 2 minutes.
Yeah, great. Well, thank you so much for that question. I haven't seen, and in the English context, I do see that debate playing out a lot more actually than in the American context. And the area where it comes up most, I think, now is actually really in current affairs, where in fact there is the Office of Pardon Attorney, which processes all of these pardons in the more administrative way, going back to, the sort of 18th century tradition. But even though it was started in the late 19th century, but in fact, a lot of the pardons that they process are not granted, and then instead you have the president sort of coming in and accepting other pardons, right? And then there's this sense of, well, both that there's something culpable about that acceptance of these, those grants of pardon because they're somehow corrupt, but then also that they're sort of based on personal favoritism, and that they've tended to dishonor the president in a way more than actually increasing the president's honor. Thanks.
Okay. Well, we probably should wind up there. So thanks very much.